I appreciate everyone being here today. Welcome to full Judiciary early version, early edition this week, I guess, inside edition. Madam Clerk, if you open board members, let's go ahead and get signed in. So everybody knows we're waiting on Representative Powell. No pressure. All right, Madam Clerk, if you please take the roll.
Mr. Chair, you have 18 members present. You have a quorum.
Very good. Members, any personal orders or announcements before we get started? You do? Vice Chair Davis, did you have one? Oh, she's on. Okay. Looks like we don't. All right, we have a calendar. Let's go ahead and just one housekeeping matter. We're going to roll item 16, House Bill 2064, to the hill of today of this calendar without objection. That's House Bill, item 16, House Bill 2064 to the hill of today's calendar, of this calendar. And then we'll take up item number 1, House Bill 1837. So you got a motion and a second, and we have been and on this bill, spent some time on it last meeting. We've already adopted House Amendment 16114, and you're recognized, sir.
Thank you, Mr. Chairman. As y'all know, protecting private property rights is fundamental, and I want to make sure that we get this exactly right. After reviewing the language and making in changes in House Bill 1837, I believe this legislation still needs some additional work to ensure it fully protects landowners and is clear in its application. Out of respect for the committee and those impacted, I'm going to take this bill off notice today, and I thank you, and I will continue to work on it.
Very good. Members, any objection to taking House Bill 1837 off notice? All right, seeing none. And if we could move to members, item 55, that's House Bill 1690. That's also by Representative Hicks. Second. You got a motion and a second there. And the amendment's coming from Transportation. I've been told we don't need to take action on that amendment, so you're properly recognized.
Thank you, Mr. Chairman. This bill is about a simple principle. If you drive on Tennessee roads, you should be financially responsible for the damages you cause. Right now, too many uninsured drivers are shifting the burden into responsible families, the insured driver, the small business owner, the single mom paying her premiums every month. And let's be honest, the penalties today are so low, for some it's cheaper to gamble than to comply. That's not accountability. That's an incentive to ignore the law. This legislation fixes that. First, it requires proof of financial responsibility before the vehicle can be registered or renewed. Second, it increases penalties for repeat offenders. If you knowingly break the law, there should be real consequences. Third, it modernizes the verification system so we can identify non-compliance efficiency and fairly. And finally, it places a reasonable cap of non-economic damages for those who choose to drive uninsured, while preserving full economic damages for protecting passengers. Members, this does not punish responsible drivers. If you carry insurance, you will never pay $1 under this bill. But if you choose to ignore the law, you should not expect the rest of Tennessee to carry the risk for you. This is about fairness, this is about accountability, and this is about protecting responsible Tennesseans. I respectfully ask for your support.
Very good. Members, I have Leader Lamberth. You are recognized.
Please roll me after Chairman Doggett.
Very good. Next on us, I have Vice Chair Davis. You're recognized.
Thank you, sponsor. Thank you, sponsor. I just want to say that I know in speaking with our clerks, there is an issue out there. A lot of times people will come in with proof of insurance and then they'll cancel it about a month or so after they've had it. And so this puts some teeth into that to ensure that they keep and hold that insurance all the time. So I want to say thank you very much for doing that for people that are trying to cheat our system.
Very good. Representative Hicks.
Thank you, Chairman. And in the bill, what we're going to do on that is we're going to collect data for a couple of years. And then that part of this bill will actually sunset. So we'll come back to this, but this data will be kept in order to find out how many people do go get insurance, get their registration, and then drop it. So we will know from this data for about a year and a half. So thank you.
Chairman Doggett, you recognize.
All right. Thank you, Mr. Chairman. My question was in regards to, I know with insurance companies, there's generally about a 9-day grace period that you have if your insurance was to lapse. Would this bill affect that if you were operating in that grace period?
Representative Hicks.
Thank you, Mr. Chairman. Under this bill, you actually now have a larger grace period. You have about 60 days before the first actual fine goes out. So if you are not in compliance, or if there's a lapse, or if there is for some reason that you let your insurance lapse, there is ample time in this legislation for you to be able to overcome that and go get your insurance.
Chairman Doggett.
Thank you, sir. And thank you for the response. Also, something that you had said, talking about the non-economic damages. Can you elaborate on that just a little bit?
What it does, thank you, Mr. Chairman. It puts a cap on non-economic damages for someone that chooses not to carry insurance is what it does. And that cap is $375,000 instead of $750,000, what it is now. So that's the difference. It does not include any passengers. It is only the person that chooses to have a vehicle that is not insured that would be that the cap would take care of.
Chairman Doggett.
Thank you.
Very good. Leader Lambert, you recognize.
Move previous question.
Very good. Members, you've heard the motion. Any objection? All right, seeing none. Looks like we're ready to vote. Send House Bill 1690 to Finance, Ways and Means. Madam Clerk, if you'd open the board, members, all those in favor, vote aye. Those opposed, vote no. Every member vote, any member, let's change the vote. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 3 noes, and 0 present not voting.
Very good. House Bill 1690 is moving to Finance, Ways and Means.
Thank you, Chairman. Thank you, committee.
And members, we could move down to item 76. That's also Representative Hicks's bill as well. And that is House Bill 1471. You got a motion in a second. Members, we're looking at House Amendment 15621. Representative Hicks, is that accurate?
That is accurate. Thank
We
you,
got a
Chairman.
motion in a second on that. Members, we want to go ahead and adopt that. Any objection to doing so? Seeing none. All those in favor of adopting House Amendment, lost my place, 15621 to House Bill 1471, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. This amendment creates a pilot program in Northeast Tennessee to expand access to drug court treatment, or recovery court, better known. It gives judges discretion to admit appropriate participants. This is not automatic eligibility. It maintains strong public safeguards by excluding true violent offenders, those involving weapons, serious injury, or prior violent felonies. It focuses on nonviolent individuals struggling with addiction, where treatment is proven to reduce repeated crime. This is a temporary pilot through 2028, so we can measure results before expanding anything statewide. This is smart, controlled way to get people into recovery, reduce recidivism, and protect public safety all at the same time. Thank you, Mr. Chairman.
Members, any questions? Leader Lambert, you're recognized.
Thank you, Mr. Chairman. And I apologize, I didn't get a chance to find you on this one beforehand, but I was a big fan of the bill before it got truncated down to just a pilot. So, I mean, I have folks in my district that have a criminal history that, while bad, are at a point in life where they greatly need recovery court. I'm not wild about telling those folks no if the judge, the district attorney, their attorney, and everybody in the process feels like they'd be a good participant in the program. Again, it's an optional program. If you don't mind me asking, why are we going to a pilot program when a statewide program would be more beneficial?
Representative Hicks.
Thank you, Mr. Chairman. Financial reasons. I think the Department of Mental Health and Substance Abuse is very unclear on what this program will cost. I think that what they turned into physical review and what came out of physical review was two different numbers. And so they are extremely worried about that. I agree. Recovery court is a extremely important process that we should have in all of our county jails and prisons. When Tennessee has decided to be tough on crime, that's a great thing. Okay. But when folks are struggling with addiction, and that is 100% their biggest issue, we need to get those folks help, and recovery court really keeps those folks accountable. I mean, I've witnessed it, and it's just great program. So I couldn't agree more that it needs to be statewide.
Leader Lambert.
Are you still open to opening this up to additional counties, if not statewide?
If we,
President Hicks.
Thank you, Mr. Chairman. If we can get the funding, I'm 100% open to opening it statewide.
Leader Lambert.
Mr. Chairman, I mean, the original bill has other fiscal impact on it. I'd be happy to meet with you and the department or whoever else, but I mean, it doesn't have a state fiscal note on it at this juncture. And I can't imagine why this would have some sort of significant financial impact from a negative. It certainly will have a positive, because there will be people that are not in jail or prison that are getting help in a program that everybody agrees they need. So, Mr. Chairman, it's your bill. I'm good with whatever you want to do, but I'd like to see it be more than just a pilot. That's just my opinion.
President Hicks. All right. Members, any additional questions? Seeing none, we ready to vote? Any objection to the question? Madam Clerk, if you'd open the board. Members will be voting to send House Bill 1471 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. There been voting. Members, let's change the vote. All right. I'm waiting. Madam Clerk, please take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 1 present not voting.
Very good. Members, House Bill 1471 as amended is moving to calendar and rules.
Thank you, Mr. Chairman. Thank you all committee.
Members, that brings us back to item 2. That's House Bill 1872. Speaker Zachary. And I'm looking at 2 amendments. I have 15559 and 15499.
Yes, sir. That's correct, Mr. Chairman.
Very good. Members, any objection to taking up House Amendment 15559? Got a motion and section. Any objection? All those in favor, vote aye. Aye. Opposed, no. Ayes have it. Now we're looking at House Amendment 15499. Do you want to adopt them both?
Yes, sir. Please, Mr. Chairman.
Okay. If we could, let's roll this bill one space. One
Okay.
space, without objection. That brings us to item 3, House Bill 1503. And Leader Lambert, I believe I may have called him.
I apologize,
Thank
Mr.
you, sir.
Chairman. We were conversing about a totally separate bill, but a member from another committee that was trying to share an amendment with me, and I apologize. Are we on House Bill 1503, I assume?
Yes, Leader Lambert, we are on House Bill 1503. You have a motion and a second, and I'm looking at an amendment from Commerce. I don't think we have to take action on this. We don't.
015308, Mr. Chairman.
It's on it. We don't have to take action,
Yes, sir,
so
Mr.
you're
Chairman.
properly recognized.
Mr. Chairman, this is literally a cleanup from the hemp legislation we had last year, that in talking to all interested parties, there were a couple of tweaks that just need to be made so that come July 1st, this is rolled out statewide in a way that works for both retailers and customers and the department and everybody.
Very good. You've heard the explanation. Members, any questions? Chairman Todd, you recognize.
Can you give a little more detail on what we're actually freeing up or doing in this? I've got some constituents that have been asking a lot of questions, and I've been in conversations with the department and ABC to try to sort through who does what and how it's going to affect each one of these folks. And so I'm very interested to see what this does actually.
Bill Lambert.
Yes, it deals with making sure that the background checks that can be done on a licensee, that ABC can actually do those background checks. There was some question in the original bill as to whether or not that could occur. On the QR code that's on there for the testing, there was a previous, in the original version we passed last year, that QR code had to go to the exact spot on the website. As long as it goes to a site where that's easily accessible, that should be permissible, should be plenty. And that webpage, it has specifications in there on how easy that has to be. It deals with the size of the actual notification on the packaging that wasn't as succinct as it could be last year, and then how some of the containers are packaged. And so I believe I've hit pretty much every aspect of this.
Chairman Todd.
Okay, thank you. Some of the concerns that have been expressed to me is products, just CBD products by themselves with no THC component now being restricted to mail order only, like the distribution of that has been changed or will be very soon. And so some of these very benign products that a lot of people are using, they're now having to shift to something, a totally different way of getting them. And a lot of our retailers that have been relying on that for income are getting hammered. It's the way I'm understanding. I'm still asking questions to make sure that the department and the ABC can get me accurate answers on that. Obviously, this doesn't address those issues, but that is something that's an ongoing concern. So thank you, Mr. Chairman.
Very good. Any response, Leader Lambert?
Mr. Chairman, that this particular bill as amendment doesn't touch any of that. All that's under the bill from last year. And quite frankly, what the federal government has now come in and change the federal parameters on this. So this is going to take a while, members, for the hemp and cannabis markets that are in Tennessee to be able to kind of reset based on what federal regulations have been put on them. And so our bill from last year sets up a very good regulatory framework that can address much of what you said. This just updates the nuts and bolts to make sure it works for everybody.
Very good. Chairman Todd, any follow-up? All right, members, anyone else? Any objection to the question? All right, seeing none. Madam Clerk, you'd open the board. Members, we're voting to send House Bill 1503 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote, please.
Mr. Chair, you have 17 ayes, 0 noes, and 1 present not voting.
Very good. House Bill 1503 is moving to calendar and rules. And just an announcement for members that are out there. From this point forward, we're going to be working straight down this calendar. We're not going to be able to hop around anymore. We've got some bills that have been on here for weeks at a time. So for at least this committee session here, we're going to be working straight down this calendar from this point forward. So just let y'all know you don't have to hang out if you don't want to. Members, folks, that brings us back to item 2, House Bill 1872.
Motion.
Members, we already adopted House Amendment 1559, and that is the appropriate amendment as I understand it. Do I have a motion in a second? We've already done that. Back up. You're probably recognized.
Thank you, Mr. Chairman. My apologies for the confusion. I think we filed an amendment twice. Members, this is a patient protection bill. Simply, it creates a civil cause of action against a healthcare professional by a patient who has suffered an injury that resulted from a gender transition procedure if the reason that person consented to the medical procedure was due to coercion as defined by TCA by the healthcare professional. That I'll be glad to answer any questions.
Very good. Members, you heard the explanation. Any questions for Speaker Zachary? All right, seeing none, we ready to vote? Any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, all those in favor of sending House Bill 1872 as amended to calendar and rules, vote aye. Those opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 3 noes, and 0 present not voting.
Very good. House Bill 1872 as amended is moving to calendar and rules.
Thank you, Mr. Chairman, Committee.
Very good. And if we could, let's move down to item number 5. That's House Bill 2527. And as I understand, it looks like, I believe Chair Lady Littleton, are you carrying this one? Yeah, House Bill 2527.
There is an amendment on it. Is that following, is that going with the bill?
There is. It looks like it's 14757.
That's it. Mhm.
Members have a motion. I have a second. Any objection to adopting this amendment? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. This bill as amended requires instead of authorizes child protective teams to include representatives from one non-governmental agency specialized in combating the commercial sexual exploitation of minors for cases involving an allegation that a child is a victim of human trafficking offense. Requires members of every child protective team to annually complete 15 hours of training related to severe child abuse and child sexual abuse provided by the Department of Children's Services to be developed in consultation with the Administrative Office of the Courts, the State Chapter of Child Advocacy Centers, Tennessee District Attorneys General Conference, and the Tennessee Sheriff's Association and the Tennessee Association of Chiefs of Police.
All right, thank you for the explanation. Members, you've heard the explanation. Any questions for Chair Lady Littleton? All right, seeing none, are we ready to vote? Any objection to the question? All right, Madam Clerk, if you open the board, members are going to be voting to send House Bill 2527 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. Is there anybody voted? Let's change the vote. All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2527 as amended is moving to calendar and rules. If we could, that brings us to item 6, House Bill 2012. You got a motion and a second, Chair Lady Littleton, and I'm not seeing an amendment on this one, so you're properly recognized.
Thank you, Mr. Chairman. This creates a civil action for individuals who are the subject of an intimate image that is intentionally disclosed without said individual's consent in certain circumstances.
Very good. Members, you've heard the explanation. Any questions for Chair Lady Littleton? Any objection to the question? All right, members, looks like we're ready to vote to send House Bill 2012 to calendar and rules. All those in favor vote aye. Madam Clerk, you'd open the board. Thank you. All those in favor vote aye. Opposed vote no. Has everyone voted? Any members change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2012 is moving to calendar and rules. That brings us to item number 7, House Bill 2014. By Chair Lady Littleton, you've got a motion and a second. I'm not looking at seeing any amendments here, so it looks like you're properly recognized.
Thank you, Mr. Chairman. This bill requires a person convicted of vehicular homicide by intoxication to be punished by a range 2 offender if the person, as a result of the same course of conduct, is also convicted of leaving the scene of the accident. Allows a person to be sentenced as a range 3 offender if appropriate.
Very good. Members, you've heard the explanation. Any questions? All right, Representative Johnson, you're recognized.
Yes, thank you, Mr. Chair. I guess the question I hear is about what if there were extenuating circumstances? Someone is under the influence. Maybe normally they would have stopped. They wake up, they're sober, like, oh my God, and they turn themselves in. Are there any sort of, my concern is like there's no judicial discretion here if there are certain extenuating or mitigating circumstances.
Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. That's correct.
Any follow-up? Representative Johnson, any follow-up? Okay, great.
She answered the question. Thank you.
Awesome. Members, any additional questions? All right, seeing none, we're ready to vote. Any objection to the question? Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 2014 to calendar and rules. All those in favor vote aye. Opposed vote no. So everyone voted. Any members, let's change the vote. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 1 present not voting.
Very good. Members, House Bill 2014 is moving to calendar and rules. That brings, we're going to move down to item 12, House Bill 2376. Chairman Doggett. You got a motion and a second. You're probably recognized.
Yes, sir. Thank you, Mr. Chairman. What this bill does, it makes it permissive. Several years ago, the General Assembly changed the law from being able to carry firearms into the courthouse. And so what this does, it currently, there's no provisions that would allow the sheriff, the keeper of the courthouse, to install some type of storage locker there for individuals that may be coming to the courthouse to pay their property tax or to see the assessor or something like that. So this is all it is. It's completely permissive. It doesn't mandate anything. It just allows the sheriff to be able to install something before the metal detectors.
Very good. Members, you've heard the explanation. Any questions? Seeing none, any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 2376 to calendar and rules. All those in favor vote aye. Opposed vote no. Every member voted. Any member, please change the vote. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2376 moving to calendar and rolls. That brings us to item 13, and we will roll. If we could, we'll just go out of order and just move on down to item 14. That's House Bill 2153 by Vice Chair Davis. You got a motion and a second, and I'm looking at House Amendment 13865.
Thank you, Mr. Chairman, and I appreciate being allowed to speak to this piece of legislation. I have a constituent and a very close friend who was harmed by her domestic partner and in a way that caused permanent damage for her. And so I brought this legislation forward, not only for her, but all of the victims of domestic violence in order to have enhanced sentencing. Unfortunately, this piece of legislation has been subbed in the Senate, and so I ask that it be taken off notice.
Members, you heard the request. Any objection? All right. Without objection, House Bill 2153 will be taken off notice. And that brings us down to item number 15. That's House Bill 2065 by Chairman Todd.
Second.
And Chairman Todd, I have House Amendment 13685. Is that correct?
Yes, sir.
Members, we want to go ahead and adopt that amendment. Any objection to adopting House Amendment 13685 to House Bill 2065? All right, seeing none, all those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill adds disrupting religious assemblies to the offense of aggravated criminal trespass. The recent incident in Minneapolis, St. Paul, where protesters entered city's church during worship service and disrupted the congregation's ability to freely worship has highlighted gaps in many states' criminal trespass and public assembly laws, particularly regarding places of worship. This bill directly addresses that type of conduct by expanding the aggravated criminal trespass statute to explicitly prohibit entering a house of worship without consent and disrupting a religious service, making the disruption a Class D felony.
Members, you've heard the explanation. Any questions for Chairman Todd? Representative Salinas, you're recognized.
What if, for example, in Memphis, we had the mayor give his address in a church? If people wanted to protest what the mayor was saying, how would your bill apply in that case?
Chairman Todd.
The way this would apply is if anyone that's a member of that congregation asks someone to leave because they're trespassing, then if they are disrupting at that point or after that point, then they would be guilty of this. So that's it. It's not if someone is just there to hear or observe, but when they start disrupting and are asked to leave.
Representative Salinas, any follow-up?
So that would be the case even if it's not a religious service. For example, he was giving the state of Memphis address. It wasn't a religious service.
Chairman Todd.
I believe it does relate to religious services only. Double checking the wording so I can point you to the right spot there. It is a religious assembly is what this references.
Okay, thank you.
Very good. Members, any additional questions for Chairman Todd? Seeing none. Any objection to the question? Seeing none. Members, look like we're ready to vote. Send House Bill 2065 as amended to Finance, Ways, and Means. All those in favor vote aye. Madam Clerk, if you open the board. All those in favor vote aye. Opposed, vote no. Does any member vote? Any member, let's change the vote. All right, very good. Madam Clerk, if you take the vote.
Mr. Chair, you have 14 ayes, 4 noes, and 0 present not voting.
Very good. Members, House Bill 2065 as amended is moving to Finance, Ways, and Means. And that brings us down to now item 17. That's House Bill 1456 by Chairman Bozo. So you got a motion and a second. I don't see an amendment on this thing. You're probably recognized.
Thank you, Mr. Chairman. Members, this is a bill that concerns our Tennessee Claims Commission. It seeks to increase limits of claims filed in the Tennessee Claims Commission from the amounts that are set forth currently in the statute that were put in place in 1984. And specifically, it would increase from $300,000 to $500,000, the limit of a claim for each claimant, and would increase from 1 million to 1.5 million, the amount of claims that can be pursued given a particular occurrence. By way of explanation, if you were to consider the cost of living increases according to the CPI index. $300,000 in 1984 is now worth approximately $935,000. $1 million in 1984 is worth slightly more now than $3.1 million. So these increases to the limits are modest by comparison, and we move their adoption, Mr. Chairman.
Very good. Thank you for that explanation. Members, any questions for Chairman Bolso? Seeing none, any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1456 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Every member voted. Member wish to change the vote. Very good. Madam Clerk, if you'd take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 1456 moving to Finance, Ways and Means. And that brings us down to, members, without objection, we're going to move down to item 19. That's House Bill 1528. So you got a motion and a second. It looks like we have a health amendment traveling with this. I don't believe there's any need for action, so you're properly recognized.
Thank you, Mr. Chairman. Members, this is a bill that seeks to amend our wrongful death statute. Currently, a presumption arises against the claim of a surviving spouse if there has been what's known as a willful withdrawal after 2 years. Typically, the surviving spouse is the person who brings an action in the event of a wrongful death case. And here, in order to protect the interests of the surviving spouse further, the bill simply extends from 2 years to 3 years, the period of time before which a presumption would arise that the surviving spouse has willfully withdrawn from the marriage and therefore would not have standing to bring a case under the Wrongful Death Act. And that, Mr. Chairman, is the summary of the motion.
Very good. Members, you heard the explanation. Any questions? Any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1528 to calendar and rules. All those in favor vote aye. Opposed, vote no. Is there a member voting? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 3 noes, and 0 present not voting.
Very good. Members, House Bill 1528 is moving to calendar and rules. That brings us to item 20, House Bill 1529. By Chairman Bolzo, I don't see an amendment on this one. You're properly recognized.
Thank you, Mr. Chairman. Members, this bill simply designates May 1 of each year on our calendar as Law Day. It follows something that was done all the way back during President Eisenhower's administration, as commemorating Loyalty Day and Law Day, the loyalty to the rule of law on the 1st of May. And with that, Mr. Chairman, I'm ready for questions.
Very good, members. You've heard the explanation. Any questions? Seeing none, any objection to the question? Seeing none, Madam Clerk, we'd open the board. Members, we'll be voting to send House Bill 1529 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 1529 is moving to calendar and rules. Members, without objection, we're going to move to item 24. That's House Bill 2451 by Representative Garrett. Sir, you've got a motion and a second, and I'm not seeing an amendment traveling with this.
Thank you, Mr. Chairman. Sorry about that. Yeah, dude, there's no amendment, so it's ready to rock.
Very good. You're properly recognized. You have a motion in a second.
Thank you, Mr. Chairman. This piece of legislation is brought to me by the Tennessee Bar Association. It clarifies the Tennessee Uniform Partition of Heirs Act that does not apply when property has to be brought back into an estate. And it also redefines and currently aligns our spousal share if you elect against the will with new current federal law. So that's all this piece of legislation does. I'll be happy to take any questions.
All right, very good. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. And Representative Garrett, is this your last estate bill that we will see from you as a state representative? Because you've carried about 20 of them.
I believe it is, Mr. Leader.
Thank goodness.
All right, members, any additional questions? Any objection to the question? All right, members, Madam Clerk, if you'd open the board, members, we're going to be voting to send House Bill 2451 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote, please.
Mr. Chair, you have 14 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 2451 is moving to calendar and rules. That brings us to item 25. That is House Bill 2452. You have a first and a second, and I'm not seeing an amendment traveling with this, and you're probably recognized.
That's right. Thank you, Mr. Chairman. This legislation updates Tennessee law governing expungements. The way it currently reads is there's a violent versus nonviolent definition. We're simply taking that out and actually explicitly putting in the code what cannot be expunged, and it's most of those violent crimes that already exist. That's the only piece of legislation. What this does, I'll be happy to take any questions.
Members, any questions? I have Representative Johnson. You recognize?
Thank you, Mr. Chairman. Is an attempt to commit a violent offense considered a violent crime?
Representative Garrett.
Thank you, Mr. Chairman. That's the exact reason why this piece of legislation exists, because it lists the specific crimes that are not expungible if you get a pardon and you get recommended by the pardon board. That the legislation lists those crimes that are excluded from that. If that's not on the list, it's not part of this piece of legislation.
Okay, so then ultimately, are we expanding the ability to get an expunction?
President Garrett.
Thank you, Mr. Chairman. We're just simply removing how they define violent versus nonviolent crimes, because that can be, can be some issues with that. So that's why we've just listed the specific crimes in this piece of legislation that cannot be expunged. And they're the worst ones that you can think of. Even if you get a pardon, even if you get if you get recommended for parole, and then you get a pardon by the governor. Those crimes are still not expungible that are specifically listed in this piece of legislation.
Right, and that's, I guess, what I'm just trying to determine. Are we actually expanding the ability to get an expunction, or are we limiting it more? Because, I mean, there's a way to look at it. We're actually expanding your ability to get an expungement.
Representative Garrett, you recognize?
Thank you, Mr. Chairman. If you look at it
How do
under
you see
Section
it?
2, subsection A, and then I through 7, you will see what crimes there are listed that are considered violent crimes, that even if you get a pardon from the governor, you cannot get expungement of those crimes. That's the simple what this piece of legislation does.
And I don't see any attempts on there, by the way.
That's right.
So if that
So the
answers your
attempt is not on there. So it actually is increasing. Okay, thank you.
question. Leader Lambert, you recognize?
To my friend from Knox County, yes, just a little bit. So it's expanding just a little bit. We went from a general list to a specific list. That's what the bill does. And I've helped work on this a little bit. The type of crimes that are listed as violent crimes has expanded over the years with legislation that has passed. And so it's gone beyond kind of what the original list was when this statute was first put in. So instead of having like a moving target, this just lists kind of the worst of the worst crimes and says, look, you can't get these expunged, but it is expanding it just a little bit on who could get expungements, because there's some crimes that are on there that you probably would still consider violent, but they're not kind of that worst of the worst. So it's gone from a generalized list that has changed over time to a very specific list where everybody knows, the courts, the judges, the governor's office, before he even issues a pardon to anybody, knows, hey, if you're committing one of those offenses, even a pardon's not going to get you an expungement. But if you're anything else, at least if the parole board recommended an expungement and the judge felt like that was in the best interest of justice, I think is what the wording of the statute is, you know that if it's outside that list. So it expands it just a little bit.
Very good. And I want to make it for clarification, attempt does apply for these 7. So just to make that clear, I was wrong. Members, any additional questions? Any objection to the question? Madam Clerk, if you'd open the board. Members, we'll be voting to send House Bill 2452 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any members change their vote? Madam Clerk, if you'd take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 1 present not voting.
Very good. House Bill 2452 is moving to calendar and rules. And that brings us to item 26. That's House Bill 2174. Representative Travis, sir.
Thank you, Mr. Chairman and committee. I have a amendment on this, sir.
Which I'm looking at 3. I have the latest one is 14845.
Yes, sir.
That's right. 14845. Is that what you'd like to move forward with?
Yes, sir. That's your amendment.
Very good. You have, all right, we're going to do it then. All right. You have a motion and a second. You're properly recognized. Members, we'll go ahead and excuse me, got a motion and a second on the amendment. Members, we'll go ahead and adopt that amendment. Any objection? All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended.
Thank you, Mr. Chairman. This bill as amended allows a current or former judge to carry a handgun or weapon inside any building in which judicial proceedings are in progress or not in progress. A current former judge must complete an enhanced handgun training course or equivalent to achieve this carrying privilege. And
Very
then I
good.
will take any questions.
Members, you heard the explanation. Any questions? Seeing none. Any objection to the question? Seeing none. Members will be voting to send House Bill 2174 as amended to calendar and rules. All those in favor vote aye. Madam Clerk, will you open the board? Opposed, vote no. Oh, excuse. Oops. Every member voted. Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 2 noes, and 2 present not voting.
Very good. Members, House Bill 2174 is moving to, as amended, is moving to calendar and rules. And that brings us to item 27. That's House Bill 2127 by Representative Alexander. Second. And I'm looking at House Amendment 15027.
That is correct.
Very good, members. We want to go ahead and adopt that. I have a motion and a second. Any objection to adopting House Amendment 15027 to House Bill 2127? Seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman, and thank you, committee. As you probably remember, in the past, I brought you legislation over the last couple of years called April's Law, which we set to protect our children from being put into homes that were abusive and back into bad situations that a minor might get hurt. This bill, all it does is change the word from change to from temporary, not contemporary, sorry, from to also include temporary custodies as well as permanent. And that's basically all it does. I've got some other things if you all need more information.
Thank you for that explanation. Members, any questions? Representative Johnson, you're recognized.
So let me make sure I've got the right, but is this one that gets rid of res judicata? And I'm just curious, that's a longstanding practice. And so are we sure this is a good idea?
This bill does not get rid of that.
Okay, thank you.
Okay, it does not. That is already in code. And we actually, in April's Law last year that we passed, we moved that to the top of the list of what judges needed to look at. Okay, so
Okay.
it does not.
And this isn't asking courts to relitigate something that's already been litigated.
No, it is not.
Thank you.
Very good. Members, any additional questions? Any objection to the question? Madam Clerk, will you open the board? Members, will be voting to send House Bill 2127 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 2127 as amended is moving to calendar and rules. And that brings us to item 28. That's House Bill 590 by Representative Ashley. So you have a motion and a second. I'm looking at House Amendment 14970. Yes. All right, members, you heard that. Do we want to go ahead and adopt that amendment? I've got a motion and a second. Any objection to the question? All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended.
Thank you, Mr. Chairman. This bill requires a court that is determining a child custody order to consider the best interest of the child as a paramount consideration.
Very good. Thank you for that explanation. We're just reinforcing that we're going to keep the children first here. So, members, any questions for Representative Ashley? Seeing none. Any objection to the question? Seeing none, Madam Clerk, if you'd open the board. Members, we'll be voting to send House Bill 590 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 590 as amended is moving to calendar and rules. That brings us to item 29. That's House Bill 1644. You got a motion and a second. I'm looking at House Amendment 14113.
Yes, Mr. Chairman.
Very good, members. You've heard it. Motion. You got a motion and a second. Members, want to go ahead and adopt this amendment? All right. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on House Bill 1644 as amended.
Thank you, Mr. Chairman. This bill aims to prevent the abuse of nitrous oxide by banning the sale of nitrous oxide at convenience stores, vape shops, or any kind of gas stations or liquor stores. It is commonly known in the medical circles as laughing gas and is used to dispense canned whipped cream in restaurants. In teenage circles, it's called whippets. Violation results in civil penalties and seizure of contraband. First violation is $2,500 and civil penalty and seizure of the nitrous oxide. Second subsequent violation will be $5,000 in civil penalties, seizure of nitrous oxide, and revocation of retail certificates, permits, or licensees for beer, wine, alcohol, or hemp-derived cannabinoids. Retailer sellers can reapply for revoked license after 12 months. It is a Class C felony for any person to sell, deliver, or give away nitrous oxide if they suspect it will be used for intoxication or other impairing effects. That's what this bill does.
Thank you for the explanation. Members, any questions? Any objection to the question? Madam Clerk, you'd open the board. Members, when we voting to send House Bill 1644 as amended to calendar rules, all those in favor vote aye. Opposed, vote no. Some member voted. Any member wish to change the vote? Very good. Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 1644 as amended is moving to calendar and rules. That brings us to item 30. That's House Bill 1707. Got a motion and a second. I'm looking at House Amendment 13193. Got a motion and a second. Members, we'll go ahead and adopt that amendment. Any objection? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and Representative Scarborough, you're recognized.
HB 1707 requires that all courts in Tennessee must cooperate with federal immigration authorities when they are enforcing immigration laws. In this bill, if a judge obstructs lawful federal immigration enforcement, they can be reported to Tennessee Board of Judicial Conduct, where the board can investigate the judge for judicial misconduct. Such as found, it could be grounds for removal from office. In conclusion, this bill makes it clear that Tennessee courts must cooperate with federal immigration enforcement, or judges may face disciplinary action.
Very good, members. You've heard the explanation. Any questions? Representative Johnson, you recognized.
Thank you, Mr. Chairman. Yes, are there any examples of this happening in Tennessee? Because I believe you can already refer them to the Board of Judicial Conduct. But is this absolutely happened in Tennessee?
Representative Scarborough, you recognized, sir.
I can't speak to a specific event. What I'd like to consider here is this is a proactive bill. You know, as a leader and executive and with over 25 years in the public policy arena, nothing is more disruptive or embarrassing for any kind of agency than when you find you don't have a policy to address a certain situation that has occurred. Policies are developed, and when those policies are non-existent, they become your policy becomes the practice becomes a policy. Again, this is a proactive measure, and again, I'd like to go ahead and just, my neighbor here in Knoxville, she knows my background and so forth. Again, it's just a proactive measure we're trying to take advantage of.
And thank you. I appreciate that, I guess, but I think it's already possible. And so if it were to happen, I'm just not sure what this bill is doing. But thank you.
Very good. Representative Salinas, you next on the list. You recognize?
Yeah, so would this apply to all judges? And specifically, I'm thinking of judges that hear order of protections, because you may have one partner, one person that is undocumented and one person that is, and the person that is documented is using it to keep them from getting an order of protection. So how would that apply in that type of setting?
Representative Scarborough, you recognize.
This bill does not speak to a specific event. This bill, again, it requires all courts in the state of Tennessee to cooperate with federal immigration authorities when they're enforcing immigration laws.
Very good. Any follow-up, Representative Salinas?
So it would apply to judges that are making rulings on order of protections.
Representative Scarborough?
All state courts in Tennessee
With that, I renew my motion. Very good, members. Any additional questions? All right, seeing none, any objection to the question? All right, seeing none. Members, Madam Clerk, if you open the board. Members, we're going to vote, we're going to be voting to send House Bill 1707 as amended to calendar and rules. All those in favor vote aye, opposed vote no. Has everyone voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 4 noes, and 0 present not voting.
Very good. Members, House Bill 1707 as amended is moving to calendar and rules. Without objection, we're going to move down to item 33, House Bill 2034, represented by Representative Harris. So you've got a motion and a second on the bill, and I'm looking at two amendments here. The latest drafting code is 16263. And I believe, I've been told they're the same language, so.
Thank you, Mr. Chairman. Give me 1 second. I'm just making sure it is the same language.
Let's take your time.
Okay, yes, sir. It is the same language.
Okay. Members, any objection to adopting House Amendment 16263 to House Bill 2034? Seeing none, all in favor say aye. Aye. Opposed, no. Ayes have it. All right, we're back on the bill as amended.
Thank you, Mr. Chairman, and members of the committee. House Bill 2034 gives our municipal courts a practical and responsible tool to address property blight when property owners fail to comply with local code. This is also something to make sure that the amendment helps make sure that it does not cause the locals to go over in budget wise. So this bill is something that we have worked on for Memphis and an area. So would love to have everyone's support. Thank you again.
Very good. You've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 2034 as amended to calendar rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, very good. Madam Clerk, will you take the vote?
Mr. Chair, you have 15 ayes, 1 no, and 2 present not voting.
Very good. House Bill 2034 as amended is moving to calendar and rules. That brings us to item 34, also by Representative Harris. That's House Bill 2035.
Second.
You've got a motion and a second, and I'm not seeing an amendment on this piece of legislation. You're probably recognized.
Thank you, Mr. Chairman. And this bill would give to Part 30 criminal court judge back into Shelby County. A couple of years ago, we did lose 2 judges. And after going through the caseload study, we were able to see that we were short a couple judges, but we're only asking for 1 specifically for criminal court.
We get Leader Lambert, you're recognized.
Thank you. Mayor may not be aware of this, but it was gen subbed in the Senate. Do you still want to try to go forward, or you want to take it off notice, or what would the sponsor's desire be?
Representative Harris, you're recognized.
Thank you, Mr. Chairman. And I do want to go forward with it. I think that they're still working on maybe pulling it back out of that side.
Members, without objection, we're going to roll House Bill 2035 to the hill of this calendar. All right. Members, that brings us to item 35, and I'm going to pass the gavel down to Vice Chair Davis.
All right, members, remember, I'm short, so if you have a question, you're going to have to raise your hand. So, but anyway, so we have House Bill 1964 by, we have a motion and a second. Chairman, you're recognized.
Very good. Members, what this bill does, it provides a pay raise for our part-time general sessions judges. It provides a mechanism and a formula for that. So I'd be happy to answer any questions you may have.
Members, any question on the bill? Any objections to it? All in favor? All right, let's, clerk, open the board and let's vote on House Bill 1964 moving forward to Finance, Ways and Means. All those in favor vote yes. Those opposed vote no. Clerk, can you count the vote, please?
Madam Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Well, your bill goes to Finance, Ways and Means, House Bill 1964. All right. Now, members, let's move on to item number 36, House Bill 1965 by Chairman Farmer. Chairman Farmer, We have a motion and a second. You're recognized, sir. There's no amendments on the bill, correct?
That's correct. Members, what this bill does provide employers the opportunity to give childcare for their employees. And how
Yeah.
this would do that is that it would provide certain liability protections for that employer to house these childcare facilities, which would be ran by a licensed childcare entrepreneur, and they would carry their own liability protection there. But this would give a great opportunity for an employer to offer childcare for their employees. And I move passage.
Members, do we have any questions? All right, we will vote. Madam Clerk, can you open the board for voting? All in favor, vote aye. Those opposed, vote no. Has everyone voted? Does anyone wish to change their vote? All right, Madam Clerk, please count the votes.
Madam Chair, you have 19 ayes, 0 noes, and 0 present not voting.
House Bill 1965 by Chairman Farmer moves forward to Finance, Ways and Means. Oh, calendar rules? Oh. That's correct. Apologize. So House Bill 1965 moves forward to calendar and rules. Thank you very much. So members, we're moving on to House Bill 1966 by Chairman Farmer. We have a motion and a second. Chairman, I have an amendment number on that bill.
14078.
That's what I see. All those in favor of adding amendment 14078 to House Bill 1966, say aye.
Aye.
All right. Chairman, you're recognized on your bill.
All right, very good. Members, what this bill does, it would add to the statewide quality assurance program. Well, it would add a statewide quality assurance program with regards to our children that are in DCS custody. I don't think we could have enough oversight over our kids that are in state's custody. So at this point in time, I move passage.
Chairman, thank you. All right. Representative Johnson, you're recognized.
Thank you, Madam Chairwoman. We definitely need more oversight. Can you tell me like what specifically they're going to be looking at and gathering what data with this bill?
Yeah, Madam Chair.
You're recognized.
Okay, a few things. We're going to focus on accountability and outcomes. We're going to monitor, monitoring evaluation and feedback. We're going to use data to do that from the DCS. We're looking at regional oversight with each the middle, eastern, and western districts, and we'll look at moving into a more of a permanent structure for independent and objective evaluation. We're going to align this with it's going to ensure that DCS programs are consistent with federal law, state law, and departmental policy. Of course, child-centered outcomes. We're going to look at the safety, permanency, and the child's well-being, and just look for continuous improvement. We'll look at those system gaps, those barriers, and area for improvement as well. So, and we all involve the community for stakeholder engagement as well. So, just a few things.
Representative Johnson.
So thank you. Is it going to look, one of the things that I'm hearing now in my district, a very specific, is overburdened caseloads with caseworkers. And when kiddos are removed from the home, they're being in transitional housing or housed in an office for longer than need be. So is that something they're going to be looking at as well?
You're recognized, Chairman.
Yeah, it's my understanding that is accurate, and I don't think there's anything within this that is off limits of the oversight. So,
Representative Travis, you're recognized.
Thank you, Madam Chair. Question on the bill.
Any opposition to question on the bill? Otherwise, we're going to move forward. Clerk, please open the votes for House Bill 1966 as amended, moving forward to Finance, Ways and Means. All those in favor vote aye. Those opposed vote no. Chairman? Oh, sorry. Got to count the votes. Clerk, can you count the votes for us, please, ma'am?
Madam Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Okay, there we go. So House Bill 1966 by Chairman Farmer moves forward as amended to Finance, Ways and Means. Members, we're moving to item number 38, House Bill 2078 by Chairman Farmer. I see amendment on that bill.
yeah, it's 13206, Madam Chair.
Thank you. All those in favor of amendment 103206, say aye.
Aye.
All those opposed? Okay, thank you. The ayes have it. You're recognized on your bill as amended. Thank you.
Thank you. Members, what this bill does, it just ensures that our courts are going to take a hard look with regards to removing non-victim minor children from their home. So there may be situations where there's an adult, brother, sister, some sort of family member that's been made allegations towards the family. There are situations where there's non-victim minor children in the home, and before a court can put down a bond restriction to remove or keep those children from their families, it'll require that the court within 15 days have a hearing, hear the proof, hear the facts from both the state and the defendants, and make specific determinations and findings of fact to why, if they choose to remove these kids from home, why they're doing so. So we're going to put some guardrails on that and just ensure that before we remove a child from a home, from their mother and father, that there's good reason to do so, and ensure that hearing is made in a timely fashion. So members, that's what this bill does.
Members, do we have any questions? All right, any objections to voting on House Bill 2078 as amended, moving forward to calendar and rules? Madam Clerk, can you open the board? All those in favor vote aye. Those opposed vote no. Anyone wish to change their vote? Madam Clerk, can you count the vote?
Madam Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Thank you. House Bill 2078 as amended moves forward to calendar and rules. Now we're moving on to item number 39, House Bill 2429 by Chairman Farmer. We have an amendment on that bill as well.
Very good. I believe that would be House Amendment 14353.
Yes, that's what I'm showing as well. So members, all those in favor of adopting Amendment 14353 to House Bill 2429? 14353. I apologize. Oh, I can't see that well. All right. All right. Chairman, you're recognized on your bill.
Members, in certain actions, the courts aren't allowed to award attorney's fees in child-related disputes, and this bill would help do so. That's what it does. Happy to answer any questions.
Members, any questions? Any objections to call the question? Clerk, open the board for voting. All those in favor of voting for House Bill 2429 as amended by 14353, moving forward to calendar and rules, vote yes. All those opposed, vote no. Anybody want to change their vote? Madam Clerk, count the vote, please.
Madam Chair, you have 17 ayes, 0 noes, and 2 present not voting.
Thank you. House Bill 2429 moves forward as amended to calendar and rules. Next, we're moving on to item number 40, House Bill 2494 by Chairman Farmer. There's no amendments that I show on this piece of legislation. Is that accurate?
Very good. Members, what this bill does, it allows for a pay raise beginning in 2030 for our state court, appellate court, and Supreme Court judges. And that's what the bill does. Move for passage.
Any questions for the sponsor? All those in favor of voting on the legislation, Madam Clerk, open the board. Vote aye. Those opposed, vote no. Anybody want to change their vote? Madam Clerk, please count the vote.
Madam Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Thank you. House Bill 2494 moves on to Finance, Ways, and Means.
And Madam Chair, if we could just roll item 41, 20 spaces.
How many spaces?
20.
House Bill 1971 has been moved 20 spaces. Tell clerk.
All right, members, and without objection, we're going to move back to item 13. That's House Bill 1814 by Chairman Russell. You got a motion and a second. Are you going to run Amendment 15363?
That's correct, Mr. Chairman.
Very good, members. You've heard it. Got a motion and a second. Any objection to adopting House Amendment 15363 to House Bill 1814? All right, seeing none, all in favor, vote aye. Aye. Opposed, say no. All right. Chairman Russell, we are back on the bill as amended. You're recognized.
Thank you, Mr. Chairman. Committee, House Bill 1814 as amended authorizes a person convicted of DUI of a controlled substance to agree to receive naltrexone injections in lieu of being required to operate only a motor vehicle equipped with lock device. It also specifies injections are to be at the expense of the convicted person for a period of 12 months and for additional 12 months for sequential violations. With that, Mr. Chairman, I renew my motion.
All right, members, you've heard the explanation. Any questions for Chairman Russell? Chairman Dog, you recognize.
Thank you, Mr. Chairman. Chairman Russell, in the event that the individual refuses to pay for those injections, what is the remedy for that?
Chairman Russell.
Thank you, Mr. Chairman. They would have to report this shot every month to the probation officer, and they would revoke their probation. Also let the Department of Safety know to suspend their driver's license.
Very good. Thank you.
All right, very good. Members, any additional questions? Leader Lamberth, you recognize.
Mr. Chairman, I know we've talked about this bill several times, and there was an amendment that came out of sub, and then I had anticipated an amendment coming here, but I was looking at the amendment that we just adopted. Would this give folks a complete option to just go around the ignition interlock device and just do the naloxone injections instead?
Chairman Russell.
For the first offense, DUI, and if it's a controlled substance, it gives them the option. Second offense, they would have to have both.
Leader Lamberth.
And Mr. Chairman, that's a little different than what we had talked about, and so I can't be there on that. Everybody else may be there, but the ignition lock device keeps the car from starting. That's where I've always been. I know we had talked about at one point an amendment that says if there's no alcohol detected and there's just drugs, that the naloxone injections could be very helpful. It's a great treatment tool, but I don't want that car starting if somebody's drinking alcohol. That's my biggest issue.
Yeah, this is for controlled substances only.
Mr. Chairman, can we go to legal?
Yeah.
I know that was his intention, but I read the amendment. It seemed like it came out weird.
Very good. Members, any objection going out of session here from legal? All right, seeing none. All right. Ms. Fogarty, you recognized.
Michelle Fogarty, Legal Services. So this applies to a person who's convicted of a violation of 5510-401 involving the use of a controlled substance.
Leader Lamberth.
And would that mean only a controlled substance? So if alcohol was detected, would it require the ignition lock device or allow folks to avoid it? Because that was my main concern if alcohol. Now, if it's just controlled substances and no alcohol has been detected at all, I think that's a different story.
The language says convicted of that offense involving the use of a controlled substance.
Mr. Chairman.
Leader Lamberth, you recognize.
What if alcohol was detected as well?
The language as written does not contemplate that. It just says if they were convicted of the offense of DUI involving the use of a controlled substance, and it's their first offense, and the court deems it appropriate to order the person to operate only a vehicle equipped with the ignition interlock, then the person can agree to receive the injections at their own expense in lieu of operating a car with ignition interlock.
Leader.
Nothing else for legal. Back to the sponsor, Mr. Chairman, we can.
All right, very good. Any additional questions for legal before we go back into session, members? All right, seeing none. Without objection, we'll go back into session. All right, Leader Lamberth.
Mr. Chairman, do you mind rolling about 5 spaces just so we can get with legal, make sure it's doing? I know what you described to me and I know what you want to do with the bill. I just want to make sure we don't have any unintended consequences here.
That's fine.
Okay, very good. Members, any objection rolling House Bill, item 13, House Bill 1814, 5 spaces? All right, without objection, 5 spaces. And that brings us back to item 42. That's House Bill 1271. I saw Leader Cochran down there. Very good, sir. You got a motion in a second. I've got about 3 amendments. The latest one is 16190.
Correct, Mr. Chairman. That's the amendment we'll go with.
I hit the spot. All right, members, any objection to adopting House Amendment 16190? I've got a motion in a second. Adopting House Bill or House Amendment 16190 to House Bill 1271. All right, all those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized.
Thank you, Mr. Chairman and committee. This one is pretty straightforward, just no later than January 1st, 2027. Each local government entity, or really any entity of state government, any subdivision thereof, shall revise any existing ordinance, resolution, rule, policy, procedure that includes a reference to a natural person's sex or gender to state that those terms are defined as the immutable characteristics of that person's reproductive system that identify the person as male or female. So basically, it's establishing the policy of the state of Tennessee that we recognize male and female across all entities.
Very good. Representative Travis, you're recognized.
Thank you, Mr. Chairman. A question on the bill.
Question's been called. Any objection? I'm seeing objection. Seeing three hands. All those, Madam Clerk, if you open the board, members, we voted on previous question. All those in favor of previous question, vote aye. Opposed, vote no. All right, thank you, Madam Clerk. You take the vote.
Mr. Chair, you have 16 ayes, 4 noes, and 0 present not voting.
Very good. Previous question prevails. Madam Clerk, if you'd open the board, members, we're going to be voting to send House Bill 1271 as amended to calendar rules. All those in favor vote aye. Opposed, vote no. Every member voted. Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 16 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 1271 as amended, moving to calendar rules.
Thank you, Chairman and committee.
That brings us to item 43, House Bill 181 by Chair Lady Moody. You've got a motion and a second, and I'm looking at House Amendment 14930. And you've got a motion and a second on that amendment. Members, any objection to adopting that amendment? All right, seeing all those in favor, vote aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you so much, Chairman and committee. This bill is going to amend, it will simply extend 2 deadlines that are currently in TCA. It establishes the advisory task force to review the composition of Tennessee's current judicial districts. The changes that this will make to that is, number 1, changing the deadline for the task force to complete its findings and recommend and publish a proposed statewide judicial redistricting plan to the legislature from January 1st, 2027 to January 1st, 2028. And the second change is also changing the deadline for the General Assembly to reapportion the judicial districts from December 31st, 27 to December 31st, 2028. So this 1-year deadline extension will allow the task force additional time to complete its assigned task and for the General Assembly to act on the submitted judicial redistricting plan proposal.
Very good. And members, I need to make a correction. I think I misspoke on the amendment number. It is 14903. 14903.
Correct.
All right. Thank you for that explanation. Members, any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board. Members will be voting to send House Bill 181 as amended to calendar rules. All those in favor vote aye. Opposed, vote no. Is there a member voting? Anybody wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
All right, very good. House Bill 181 as amended is moving to calendar and rules. That brings us to item 44. That's House Bill 1679. You got a motion and a second. I'm looking at House Amendment 13147. Okay, I've got a motion and a second. Members, do we want to go ahead and adopt this amendment? Any objection? All right, seeing none, all in favor vote aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman, again, and committee. Excuse me. This bill was brought to me by a constituent. His name is Scotty DeLashment. He testified. He was able to come and testify in our subcommittee, but he is also with our court. He is our court administrator. Now, this was an idea that he himself noticed that maybe this would be a good fix for this issue that we have. So what it is, it's simply an accountability for vape issues in West Tennessee is what he was seeing, but it would be statewide. But this is for regarding juveniles. And it is permissive, but what this would do is just, instead of the penalties being on the parent, which is the fine, which is $50, I believe, but the youth just kind of skate away, right? So what this would do, it would add what this would change, again, with our juveniles, that they would be redirecting the penalties away from the parents, and the youth would be given, through the courts, community service in conjunction with rehabilitative accountability. And so we thought this would get the youth, the juveniles' attention more than just having their parents be able to pay the fine. So it's permissive, but this is something that our area would be interested in implementing for sure if you pass this bill.
Very good, members. You heard the explanation. Any questions? Seeing none, seeing one. Representative Johnson, you recognize.
Is there a time amount on that for the service, community service?
Chair Lady.
Let me find it, so I'll say it correct. I think if they re-offend, that there will be some more added on to it. But I think after that first round, if they don't re-offend, they're good.
Thank you.
Thank you.
All right, very good. Members, any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, please open the board. Members will be voting to send House Bill 1679 as amended to calendar rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member, let's change their vote. All right, Madam Clerk, if you would take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
All right, very good. House Bill 1679 as amended is moving to calendar and rules. That brings us to item 45, House Bill 1733. All right, you got a motion and a second, and you're probably recognized.
Thank you so much again, members. This bill came to us from it originally was just one family that came to us, but once the other families found out about this issue, they were completely supportive of what we're trying to accomplish here. And so it was an issue regarding their daughter and a teacher assistant who was bullying their daughter. And so we contacted the Tennessee State School Board to check with them about this issue. And it is true that there is a gap in the law when it comes to reporting a non-licensed school employee and bullying. So I think currently if it's a student versus bullying a student. So what we are proposing here is also, it is true for a licensed teacher, but what we want to do here, what we're asking to do is to add all school employees. Any school employee in that building would come under this. But it doesn't change anything. They have to be convicted of bullying, the same as a licensed teacher would be. And it would hopefully not have to be used very much, but we know, unfortunately, sometimes things happen like that, and that's what this is trying to fix. This would also, if they are convicted, it would go into their record, because the other issue that happened was this person, not being under this law, went to another school district and there's no record of the issues they were having. So, any questions?
Thank you for that explanation. Members, are there any questions for Chair Lady Moody? All right, seeing none. Any objection to the question? Seeing none. Madam Clerk, if you'd open the board. Members will be voting to send House Bill 1733 to Finance, Ways and Means. All in favor vote aye. Opposed vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1733 is moving to Finance, Ways and Means. And that will, without objection, we're going to move to item 47. So, thank you. Or we would without a member. So without objection, let's move to item 50. That's Representative Martin. Very good. You've got a motion and a second, and I'm not seeing any amendments, and you're probably recognized.
Thank you, Chairman and Committee. Currently, the penalty for arson is a Class C felony unless the target was a place of worship, and this would enhance the penalty. This bill would also enhance the penalty of arson when the target is a pregnancy resource center. This bill would raise from a Class C to a Class B felony. You may recall a few years ago an attack on the Hope Clinic for women in Nashville a few years back. This was not an isolated event. Pro-life nonprofit organizations have cataloged dozens of instances of graffiti, intimidation, property damage, and arson. And this bill prioritizes the safety of these facilities, their staff, and the vulnerable women that are seeking help. And with that, I would ask for your favorable vote.
Very good, members. You've heard the explanation. Any questions? Representative Johnson, you recognize.
Thank you, Mr. Chairman. Would this include also, like in Knoxville, the Planned Parenthood Center was burned to the ground? Would it be included as well?
Chair Martin.
That doesn't include the scope of this bill. It deals with nonprofits that are resource centers for women that are seeking help in their pregnancy.
Very good. Representative Johnson, answer your question.
Yeah, I guess it does.
Very good. Representative Salinas, you recognize.
That kind of answered my question. My question was, so it doesn't include any OBGYN that also takes care of pregnancies?
Chair Martin.
This is dealing with nonprofits.
Very good.
Okay.
All right, members, any additional questions? Seeing none, any objection to the question? Seeing none, Madam Clerk, open the board. Members, we'll be voting in the House Bill 2260 to Finance, Ways and Means. All those in favor vote aye, opposed vote no. Is there a member voted? Any member wish to change the vote? All right, Madam Clerk, if you take the vote, please.
Mr. Chair, you have 17 ayes, 3 noes, and 0 present not voting.
Very good. Members, House Bill 2260 is moving to Finance, Ways and Means. We also have, by Chairman Martin, item 51, House Bill 2264. You got a motion and a second. I'm looking at House Amendment 14225. I've got a motion and a second. Members, we'll go ahead and adopt that amendment. Any objection? All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you. House Bill 2264 as amended establishes a Class A misdemeanor for those who disrupt the worship of religious assembly. Most of us have followed the events which took place earlier this year in Minneapolis, and regardless of one's political opinions or personal feelings, the right to worship is a fundamental pillar of American way of life. This federal administration stepped in to prosecute those who disrupted the services at City's Church. However, the Department of Justice on the federal level may not always prioritize religious freedom this way. This bill expresses the intent of the state of Tennessee to always uphold the right to worship. And with that, Mr. Chairman, I would stand ready for questions.
Very good. Representative Travis, you're recognized.
Thank you, Mr. Chairman. Question on the bill.
Very good. Question has been called. Any objection? Seeing none, Madam Clerk, open the board. Members, we'll be voting to send House Bill 2264 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Is there a member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 3 noes, and 1 present not voting.
Very good. Members, House Bill 2264 as amended is moving to Finance, Ways and Means. Members, that brings us back to item 13 by Chairman Russell. And we're on it. The motion and seconds there. I believe we're about to adopt House Amendment 15363.
Mr. Chairman, could we roll this 10 spaces?
Members, any objection? All right, seeing none, 10 spaces. Members, without objection, let's move to item 71. That's House Bill 2262 by Representative Martin. All right. You got a motion and a second. We're looking at House Amendment 15693. You got a motion and a second. Members, we want to adopt this amendment. Any objection? Seeing none, all those in favor vote aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Thank you, Mr. Chairman and committee. House Bill 2262 as amended offers an initial screening instrument for the Tennessee Department of Children's Services to use when investigating allegations involving a child's caregiver. In the Comptroller's December 2025 Performance Audit Report, DCS of DCS employees of the department also suggested authorizing the screening instrument for caregivers. Currently, it only applies to children and family members. Without the ability to consider the unique circumstances of each report, investigators of DCS felt forced not to substantiate reports. Page 26 of the Comptroller's report says, in cases involving non-severe abuse, a third option, such as assigning training or services to address concerns, would have been more appropriate if that choice had been available under the policy, unquote. This bill seeks to do just that. It adds caregivers to the screening instrument, which is already in the law, and if there is not an allegation of abuse or sexual assault, but it's determined that the child may still be at risk of maltreatment, then DCS can choose the appropriate level of intervention. This could be a formal investigation, an assessment, a service referral, or no further action. I want to thank the department for their conversations and assistance in getting this language right in the right posture. And with that, I would ask for your favorable recommendation.
Members, you've heard the explanation. Any questions? Seeing none. Any objection to the question? Seeing none. Madam Clerk, you'd open the board. Members, all those in favor of sending House Bill 2262 as amended to counter rules, vote aye. Those opposed, vote no. Has every member voted? Would any member wish to change their vote? Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 2262 as amended is moving to calendar rules. That brings us to item 72. That's House Bill 2263. So you've got a motion and a second. I'm not looking at seeing any amendments here. You're probably recognized.
Thank you. Chairman and committee, House Bill 2263 adds starvation resulting in the death of a livestock animal to the types of conduct that constitute a Class C felony of aggravated cruelty to livestock animal. Starvation is not a momentary act, but an extended failure to provide basic care. And when this results in the death or injury, it constitutes severe neglect that fits aggravated livestock cruelty. This does not include normal husbandry practices, market decisions, drought challenges, or veterinary care. By explicitly including starvation, this bill gives law enforcement and prosecutors clear authority to address the most egregious cases, reinforcing Tennessee's value of stewardship, responsibility, and humane animal care. With that, I would have to stand ready for any questions, Mr. Chairman.
Very good. Members, you've heard the explanation. Any questions? All right, seeing none. Any objection to the question? All right, seeing none. Members, looks like Madam Clerk, you'd open the board. Members, we'll be voting to send House Bill 2263 to Finance, Ways and Means. All those in favor vote aye, opposed vote no. Has there a member voted? Any member wish to change the vote? Madam Clerk, if you would take the vote, please.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2263 is moving to Finance, Ways and Means. Members, we could move to item 58. That's House Bill 1798 by Representative McCallum. You got a motion in a second, and I'm not seeing any amendments on here, sir, and you're probably recognized.
No, Mr. Chairman. Thank you very much. Good afternoon, members. What this bill does is a simple administrative fix. It was brought to me by my county sheriff. Simply clarifies Tennessee law to remove confusion about how fees are paid to the sheriffs or other officials for serving garnishments. It's currently unclear whether multiple garnishments in the same case qualify for separate service fees, which has led to inconsistent practices. The bill establishes that each garnishment is treated as an original service for fee purposes and ensures the sheriffs and authorized process servers are compensated for the time, labor, and administrative work required to complete each service. It allows officials to require payment in advance so local offices are not left absorbing unpaid service costs. And it creates a clear standard statewide. The legislation reduces disputes and improves predictability for courts, officials, and parties involved. Most importantly, the bill does not change the garnishment process or who may issue garnishments. It only addresses how service fees are assessed. And with that, I stand ready for any questions, Mr. Chairman and the committee.
Very good. Thank you for the explanation. Any questions, members? Seeing none, any objection to the question? Seeing none, Madam Clerk, you open the board. Members are going to be voting to send House Bill 1798 to calendar and rules. All those in favor vote aye. Opposed vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good. Members, House Bill 1798 is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
Members, and without objection, we're going to move to item 65. That's House Bill 2140. Speaker Zachary. You got a motion in a second. I'm looking at House Amendment 13344.
That's correct, Mr. Chairman.
Very good, members. You've heard it. Do I have a motion in a second? We want to take it up?
Motion.
Okay, you got a motion in a second. Members, we want to go ahead and adopt this amendment. Any objection? All right, seeing none. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman and committee. Members, since 2017, Tennessee's led the nation related to organized retail crime. Every year I have to come back before you because as criminals advance, we have to do as well. This legislation requires a minimum of 30 days in jail if a firearm is used, and then enhances the penalty from 90 to 180 days for an offense. I'll be glad to answer any questions.
Very good, members. You heard the explanation. Any questions? Seeing none. Any objection to the question? Seeing none. Madam Clerk, if you'd open the board, members will be voting to send House Bill 2140 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Someone voted. Any members change the vote? Madam Clerk, take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 2 present not voting.
Very good. Members, House Bill 2140 as amended is moving to Finance, Ways and Means.
Thank you, Mr. Chairman. Committee.
Very good. Members, we could move to item 69. Chairman Hawk. That's House Bill 2359. You got a motion in a second. Members, I'm looking at House Amendment 16240. Chairman?
That is correct, members.
Very good.
Yes.
Members, we'll go ahead and adopt this amendment. Do I have a motion in a second? Very good. Any objection to adopting House Amendment 16240 to House Bill 2359? Seeing none, all in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized.
Thank you, Chairman and members. This bill cleans up some things we did with the vape legislation last year. If you remember, we worked diligently on that. A couple of technical corrections. Closes a synthetic nicotine loophole. The original law only covered natural nicotine, so manufacturers were sidestepping it with lab-made alternatives. So synthetic nicotines are also included, and it moves enforcement to the ABC, clarifies that fines and violations are issued by the ABC, putting enforcement where it belongs. The amendment that you all just adopted does two things. It allows local law enforcement to work concurrently with the ABC on age compliance checks, as well as allows the ABC to have proper staffing to take care of this. So in a nutshell, that's what it does, Chairman and members.
All right, members, you heard the explanation. Any questions? Representative Salinas, you recognize.
My question's not to the sponsor. The amendment's not showing up on dashboard.
It's amendment drafting code 016240.
16240.
Yeah.
That's what I have. Hold on one moment. Hey, without objection, we're gonna roll this bill 2 spots. Without objection. Thank you. Members, we can move to item 61. Without objection. That's House Bill 1949. And you got a motion in a second, sir, and I'm looking at House Amendment 15039.
Thank you, Mr. Chairman and members. This particular piece of
And you got a motion in a second on the amendment. Members, we'll go ahead and adopt this amendment. Any objection? All right, seeing none. All those in favor of adopting House Amendment 15039 to House Bill 1949, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Thank you, Mr. Chairman and committee members. We all, I'm sure, are aware of the fact that the opioid epidemic has been ravaging our state, and many of our nonprofits are engaging in trying to help those who are recovering from that. This particular piece of legislation simply would direct the Opioid Abatement Council to consider when nonprofit organizations would like to have some of their funds advanced to them for use of salary to do that. And that's simply what this legislation does, Mr. Chairman and members.
All right, very good, members. You heard the explanation. Any questions? Any objection to the question? All right, members. Madam Clerk, you'd open the board. We're going to be voting to send House Bill 1949 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1949 as amended is moved into Finance, Ways and Means.
Thank you, Mr. Chairman and committee members.
And members, without objection, let's move to item 52. That's House Bill 2283 by Chair Lady Carringer. You've got a motion in a second, Chair Lady, and I'm looking at House Amendment 13839. You've got a motion in a second. Members, we want to go ahead and adopt this amendment? Oh, very good. All right. All those in favor say aye. Aye. Opposed, say no. All right. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman, and thank you, committee. House Bill 2283 is about current law authorizes Department of Children's Services to place children removed from their home in the care of relative caregivers. Currently, relative caregiver is defined as a person within a first or second or third degree of relationship to the parent or step-parent of a child who may be related through blood, marriage, or adoption. And this bill just simply prohibits DCS from requiring a relative caregiver to provide the child with the child's own bedroom unless there are specific safety or medical reasons that would make placement of the child with another child unsafe. And the amendment was worked on with the department, and it just clarifies it that the prohibition applies both to the department and any court order that grants custody or guardianship. And with that, I'll stand for questions.
Very good. And thank you for that explanation, members, excuse me, Chair Lady Carringer. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none. Members, we're going to be voting to send, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 2283 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Is there a member voted? Any member wish to change the vote? All right, very good. Madam Clerk, you take the vote.
19 ayes, 0 noes, and 0 present not voting.
All right, very good. Members, House Bill 2283 as amended is going to be moving to calendar and rules. If you'll hang right there, I'll get this other bill of yours as well. Members, without objection, if we could move to item 79. That's House Bill 2309. And you've got a motion and a second. I'm looking at House Amendment 15083.
That's correct, Chairman.
All right, very good. You got a motion and a second. Members, any objection to adopting House Amendment 15083 to House Bill 2309? All right, seeing none. All those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Okay, thank you, Chairman and Committee. The amendment drafting code 015083 does not make the bill. It just establishes criminal and civil penalties for targeting houses of worship or interfering with religious freedom. So it just requires, in addition to any sentence imposed for criminal offense of vandalism, a court must impose a fine of at least twice the total amount of any property damage, loss, or expenses related to cleaning and restoration when the offense occurs in a house of worship.
All right, members, you've heard the explanation. Any questions? Any objection to the question? All right, seeing none, Madam Clerk, you'd open the board. Members, we'll be voting to send House Bill 2309 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 3 noes, and 0 present not voting.
Very good. Members, House Bill 2309 as amended is moving to Finance, Ways and Means. And members, that'll bring us back to, I just got to hop back to Chairman Hawk. And that is item 69.
Thank you. Hope the amendment has shown up in folks' dashboards.
All right, members, any questions for Chairman Hawk? All right, very good. I'm not seeing any objection to the question. All right, seeing none, Madam Clerk, if you open the board. Members, we're going to be voting to send House Bill 2359 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member, let's change their vote. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good, members. House Bill 2359 as amended is moving to Finance, Ways and Means.
Thank you, Chairman, members.
Very good. And members, without objection, we're going to go back to move to item 77. Chair Lady Carringer, you want to hop back up here? I was going to try. You've got a motion and a second. I'm not seeing any amendments on this bill, so you probably recognize.
Is that House Bill 1924?
1922, 1922.
Okay, make sure I get the right one here. Thank you.
You're welcome. Take your time.
Okay, this just requires a sexual offender or a violent sexual offender to notify owner or operator of a campground of their sex offender status prior to beginning their overnight stay.
Surprised that's not already the law. Members,
No.
any questions? Any objection to the question? Seeing none. Members, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1922 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Is everyone voting? Let's change the vote. Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 1922 is moving to Finance, Ways and Means. And that brings us to item 78. That's House Bill 1924. You've got a motion in a second. I'm not seeing any amendments on that bill as either.
Thank you, Mr. Chairman and Committee. This just requires the Tennessee Advisory Commission on Intergovernmental Relations as TASER to study the status of the Crime Stoppers program across the state and make recommendations to enhance such programs and improve their outcome. With that, I'll stand for question.
Very good, members. You've heard the explanation. Any questions? Any objections to the question? Madam Clerk, if you'd open the board, and members will be voting to send House Bill 1924 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Is there every member voted? Any member wish to change the vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, 0 present not voting.
Very good. Members, House Bill 1924 is moving to Finance, Ways and Means.
Thank you, Chairman and Committee.
And members, without objection, let's move to item 60. I see Representative Langford's down there. So you've got a motion and a second. And I'm looking at House Amendment 13729. Is that correct?
Yes, that's correct.
You got a motion and a second. Members, any objection to adopting House Amendment 13729 to House Bill 2184? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This amendment makes 3 practical updates to the existing 3-judge panel process. It allows the venue to be set in any county rather than only where the plaintiff resides. It gives Supreme Court flexibility to appoint 1 judge from each grand division rather than relying on judges from where the case originated, and third, extends time frame for General Assembly to respond to redistricting issues from 15 to 90 days. This change improves flexibility, workload balance, and ensures realistic time frame for legislative action.
And thank you for that explanation. Leader Lamberth, you recognize.
Thank you, Mr. Chairman. Is this your first bill in the Judiciary Committee?
Very good. Representative Langford, you recognize.
Thank you, Mr. Chairman. It is.
Leader Lamberth.
Mr. Chairman, you and I have been down here quite a while. We don't normally let freshmen get bills out of Judiciary, do we?
Historically, I would take a motion.
Hey, Mr. Chairman, maybe if I do a couple questions, it might help out.
Very good. All right, you're recognized.
Well, sir, are you a lawyer?
Representative Langford.
Thank you, Mr. Chairman. No, sir, I'm not.
Leader Lamberth.
Were you a judge?
Representative Langford.
Thank you, Mr. Chairman. No, I'm not.
Leader Lamberth.
Mr. Chairman's not getting any better. I don't know. I mean, he does look like he's doing a good job, though. I hear he had a bill in ag. The chairman told me that was a pretty pleasant experience for him. Did you enjoy your trip through the ag committee?
Representative Langford.
Thank you, Mr. Chairman. I absolutely enjoyed it, especially the questions from Chairman Todd next to you.
Leader
Wow.
Lamberth.
Man, he must really need his vote on this bill. Mr. Chairman, I'm good if we go forward. If you are, but it's your committee. Mr. Chairman, whatever you want to do. But young man seems like he's doing a really good job representing his folks well.
Very good. I concur. Members, any additional questions? Any objection to the question? All right, seeing none. Members, we're going to be voting to send, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 2184 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has ever been revoted? Any member wish to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 15 ayes, 3 noes, and 0 present not voting.
Very good. House Bill 2184 as amended is moving to calendar and rules. And that puts us up
Thank you,
against
Mr. Chairman.
a hard stop at 4 o'clock. Members, so without objection, we're going to recess until noon on Wednesday.